Okay, I've got record on. It's now 10 minutes after, so we're going to go ahead and start. And contact their colleagues and remind them we have classes on Tuesday and Thursday morning at 8 a.m. I'm going to go ahead and show my screen. I have a lot of different screens open up on my computer. I'm certain my sound level's okay, or people would be saying they could not hear me. I've got a bunch of different screens opened up because we're going to, as I said, walk through the first sentence of Article 4, and then into the second sentence. We're going to compare the second sentence not being in the UN model treaty. We're going to look at the commentary. We're going to look at Fogel. We'll consider other sources. Okay. Send screen. Show my desktop. Load highlighter. And in a moment, you'll be seeing my screen. I'm going to go ahead and turn off all the video images to save y'all's bandwidth. Move on. Professor Byrnes, apply. Good. Okay. I saw that some of the students, or I received an email from Alan DeCoker that some of the students want to use the mega meeting this weekend for a study group. It's very easy to do. There are under the YouTube, as well as under your saved recorded lectures, there are how to use mega meeting. The YouTubes are only 5 minutes long. There's 2 of them you need to look at. I think everyone has looked at them. And so you can just come in and do the mega meeting. The username that everyone uses is Prof. Byrnes. The password that everyone uses is TJSL1234. It's the same for everyone. Do not set up a new classroom. I will delete it by accident. I try and keep it orderly. Use Classroom A or Classroom B. Classroom A or Classroom B. I cannot show you what that looks like because I'm in Mega Meeting projecting. And if I showed you, then it would I would be shut out of the class. However, when you come in as a host, username Prof. Byrnes, password TJSL1234, you actually only need to use the host function if you are going to project your screen. If you're not going to project your screen, you can enter as a guest. It doesn't make a difference. I don't think it uses any more bandwidth on your side to enter as a host or a guest. If it does seem to go a little bit slower, if you enter as a host, simply back out and enter as a guest. You do not have to have a host for a meeting. So you can use Classroom A or Classroom B, and over the weekends you can use International Tax. We only use it during the class times. And then be aware there's a new whiteboard feature, which is not on your YouTube videos for Mega Meeting. It was just added last week. It's a real-time text collaboration tool. And I'm going to make the, what is this called, noteboard go away. I'll open up the whiteboard. You see that on your screen now. You'll see it in a moment. And just so you see what the whiteboard is. And you can just like the note board, you can copy and paste text in here. Everybody can work on the text, change the text, and so forth. Pretty neat collaboration tool. Okay. Yeah, it showed up on my student screen now. So you see the whiteboard. Just be aware of it when you're using the Blackboard this weekend in part of your as your study group. What other major announcements do we have? Well, for this class, I want to make sure, because I haven't received any responses on it, I'm opening up your classroom under the examination forum. And under the examination forum, we find the following text. There are two assignments due for this course that are determinative of your final grade. You'll find them mentioned under the syllabus, but here's the description of the assignments under the forum final examination and due date. Just to make sure that we're all on the same page, because there are, as I see, I think there are 18 or 20 people in this course, and I see about 10 people at the lectures. The final examination consists of two parts. I want to make sure everyone gets that. It's two different parts, and they have two different due dates. The subject must be agreed between each student and myself, i.e., you must reply with your topic matter to this posting with your potential subject for me to agree to. Part 1 is to develop a minimum 3,000 word study guide, including non-US cases, with an attached pathfinder. So look at Part 1 again. Part 1 is not just a 3,000 word essay. That's exactly what it is not. It is a 3,000 word study guide. And my voice is breaking up. I see it. I can put it closer to my mouth, and I can make it go louder. I'm only on about 80%. Okay, that's at full strength. So, Part 1, which is due November 5th, there'll be no lates accepted on this. You've had more than a month. You've had 2 months. So, this was posted in the beginning of class. The assignments would be due. So Part 1 is a 3,000 word study guide. It must include non-US cases to provide analysis of an issue. You must have attached to that study guide a pathfinder and a slide presentation upon the topic of the study guide. So, what's required? By November 5th, 3,000 word study guide. A study guide is not an essay. It can include pictures, it can include any form of teaching tool or modality to get a subject across. At the IFA, International Tax Conferences, people put up these huge posters describing aspects of tax treaties here. Like 50 people do this as part of their PhD writing process. But yours will have an attached pathfinder. You'll know what a pathfinder is from Thesis 1, and a slide presentation. Part 2 is different from Part 1. Part 2 requires a 5,000 word article, which includes footnotes on the topic of the study guide. That's not due until December 5th. That article is to be publishable quality, and hopefully everybody writes an article that is of such publishable quality that you can go get it published in Tax Notes International, Journal of Taxation, or one of the other many tax journals out there, or even it could become a law review. Now, law reviews won't accept articles that are only 5,000 words. That's by far too small. Typical page has at least 500 words on it. So it works out to be about 10 pages, but when you include footnotes and so forth, it's less. So you have the next 3 months to put together your 8 to 10 page article. I would encourage you to have strong footnotes that you can publish it in one of the serious peer-reviewed or professional journals, as opposed to just a magazine. Susanna says voice is better. Before I increase the volume, I'll bring it down back to 80%. Okay, that's all I'm going to say on the final exam. It was just I haven't seen anybody respond to the examination form yet, thus I'm bringing it up now. It's certainly mentioned in your syllabus under the grades, so I'll just go there to show us how much is it worth. The final exam is worth click on my syllabus, and I've just clicked on syllabus, so we'll see that it's worth a substantial part. The study guide, so that's what's due November 5th, is worth 25% of your course grade. A final paper will be upwards of 40%. Okay, I'm going to go ahead and close that out now. But basically, slightly higher than 50% of your course grade is going to be based on you meeting the November 5th deadline and the December 5th deadline with a good product, which, if you're a working practitioner in tax treaties, your article doesn't have to be a publishable article, certainly does not have to be academically inclined. It can be direct to a core client problem. And I encourage everyone to focus on client work if you are working in the tax treaty area, so that this becomes you're killing 2 birds with 1 stone. Your course assignment for the final exam and your client work. Now, I'm closing out the tax treaties course, and we're going to get into the gist of today. I've decided to use tax analysts, as I normally do, for looking at the tax treaties. So I went into my proxy server, scrolled down the International Tax Database list, and pulled out the Tax Analysts Worldwide Tax Treaties database. I popped into Model Conventions. You'll see this shortly on your screen. So I popped into the Model Conventions and then clicked on the OECD Model Convention. On the OECD Model Convention, because I wanted to switch between screens quickly, just to show you what I did, I put my mouse cursor over the article number, which then highlights with a little line underneath it, as you should see shortly on your screen, and then I right-clicked. So, for those of you who aren't as computer savvy, just like in the Twin Classroom, I can right-click on a link and open up 2 or 3 Twin windows in New Windows, or I can open them up as tabs at the top of my browser screen. That pretty much works in any internet-based program. So here in Tax Analysts, I put my mouse cursor over Article 1, Persons Covered, and I right-click on Article 1, Persons Covered, and as you will see shortly on your student screen, it allows me to scroll down the menu that opens up and choose Open in New Window. You'll see at the bottom of my student screen that I have used the Open in New Window to achieve, I have 1, 2, 3, 4, 5, 6, 7. I have 6 or 7 windows opened up using my Open in New Window. Article 1, 2, 3, 4, commentary, and so forth. Okay. I'm just showing you this little trick to make your life easier if you don't realize it. Now, on your screen, you will see Article 4. We're going to go through the first sentence. For the purpose of this convention, I'm just waiting for it to appear on my student screen. Do you all? I don't know how latent it is. Do you all see the Article 4 on your screen yet? Can you put yes or no quickly so I know? Yes or no? Do you see the Article 4 on your screen yet? Petra says no, no, no. Okay, so your screen, your latency is the exact same as mine. Not yet. Yet. Now it just appeared for me this very moment. Can you put yes if it appeared for you? Now is Article, yeah. Petra says still not. Yes. Okay. Ken says not yet. I better open my other articles now. It'll take too long. Okay. I'm going ahead to pop my other articles open on the screen so it doesn't take so long later to have them open up. So I got Article 1, 2, and I got Article 3. Yeah, that's good. Okay. So, for purposes of this convention, the term resident of a contracting state means any person. Well, backing up to our last week's lecture, we have to ask ourselves the question, why is the term resident important? We're going to break this sentence down into its small component parts, perhaps even word by word. Now, I'm doing that to help you understand the treaty, and I'm doing it in a way the courts might look at it also. However, do not, when I look at it by sentence, clause by clause, word by word, which I'm going to do in a lot of treaty discussions with the class, and you'll see this on my recorded videos from last year that only 2 or 3 of them came out, unfortunately, because last year I was on fire and had all these ideas on treaties and broke everything down into symbolic logic. But I'm applying a statutory kind of analysis that is common in the United States. I am not meaning for you to understand what I'm doing in the terms of tax treaty interpretation. I will point out the application of tax treaty interpretation. I don't need to do that because you have 3 modules dedicated to it. Your first 3 chapters of the course are dedicated to tax treaty interpretation, and you can discuss the academic aspects, so the theoretical aspects, and then make it practical aspects of tax interpretation in your asynchronous discussions with Professor DeCoker. And I hope you're doing that. I don't follow all the asynchronous discussions. We're just applying a basic statutory interpretation approach to help you contextualize the meanings as the model treaty is written, understanding, as we said the week before, and the week before that this is only a negotiation stance used by OECD models, OECD members, yada yada. I'm not going to go back through that. So just don't be confused between our statutory approach to a tax treaty, which is a way to look at tax treaties to help you understand it, but don't take that to be the way that we interpret tax treaties. Interpretation of tax treaties is, well, you'll read modules 1 through 3, chapters 1 through 3, and there's a totally different approach. And there are actually 2 different approaches put forward in the module, and there's several variants of those approaches. Okay. Now, back to my question, the term resident of a contracting state, why is that important? So, last week, we briefly mentioned, as part 2 of our contextualization of the tax treaty, and why tax treaties are important, and what they try to accomplish, and how do they fit into the international tax world. We mentioned about who do treaties apply to. And so, we go from Article 4 to Article 1. Scope of the Convention article, or Scope of the Convention, Article 1, persons covered. You should see Article 1 on the right-hand side of your screen. I've opened it up there. Now, the article is very simple. 1 sentence. This convention shall apply to persons so now we have 1 word. We have another word, shall, who are residents, that's another magic word, of one or both of the contracting states. What does the word shall mean? Must, says our resident colleague. There's 2 ways that I analyze the meaning of legal words. Now, this is my personal analysis, because as we've seen in course materials, and for those of you in Principles of International Taxation, or for those of you who have done Thesis 1 or are in Thesis 1, you'll know that words sometimes have a common meaning, i.e., you look in a Black's Law Dictionary, or you look in the Merriam-Webster or the Oxford English Dictionary. Sometimes words have a specified meaning within the context of the act, the law, the civil code that you're looking at, and so forth. Another way of looking at definitions, though, is a regressive analysis. What does it not mean? And it still requires that you have references, whether they're common references to a dictionary like a Merriam-Webster or an Oxford, whether they're references to a legal dictionary, whether they're references to the actual statute, the text in the statute. or to some kind of jurisprudence, be it treatise or case law that has examined that word. And the word shall, well, what are other synonymous words to shall? And we had will, or must, may. And if you brainstorm the similar words that could fit within the context of taking out the word shall for a moment and just putting it as a blank space. I don't know, some of the lawyers in the room will go crazy and say, this isn't the way you do statutory interpretation, but it's for the purpose of understanding understanding this treaty article. In all treaty articles, it's just an approach, not one that you might go to the courtroom and apply, though. Okay, so I take out the word shall and I put a blank space there. So this contract, blank, apply. And then what are the synonymous words and what are the opposite words to shall? And that helps us understand what the word shall means. Now, why would I focus on the word shall? Well, the word may is similar to the word shall, but has a very different meaning. Shall is more like a will, a must. And may is like a possibility. Generally in law, it's accepted that the word shall means must, it means will, it means that whatever is shalled, that the parties, in this case to the convention, but the parties, it creates an obligation to do or not to do something. And that obligation can be relied upon. Reliance in a contractual sense, reliance in a delictual sense. Now, neither contract nor delict per se apply in this tax treaty context because the treaty is between contracting states. However, in understanding, which we'll go through in terms of treaty jurisprudence and application of the treaty to taxpayers and taxpayers bringing this treaty to court and relying upon the treaty to achieve a certain non-taxability or whatever they're trying to achieve in a courtroom or with a revenue authority, some kind of tribunal, perhaps the competent authority, which is another lecture with Marshall Langer. Whatever they're trying to achieve, that's a different set of rights. You have two parties to the treaty, which are the contracting states. And that's a horizontal relationship. Two equal parties, two contracting states. That's two persons in the international law sense of the word. Persons in that case does not equal you and me, natural people. It does not equal companies. It equals sovereigns recognized in the international community as being sovereigns. I think last week we mentioned Taiwan, or was the week before, as being a quasi-sovereign gray area, and it doesn't have tax agreements with countries that don't recognize it as the governing authority of China. It has something else. Doesn't have tax treaties. Treaties can only be entered into by sovereign nations. Okay, so persons can have many meanings, and could have the meanings of the public international law sense of the word. Now, there's also these vertical rights and almost vertical diagonal rights. You have the vertical right of a nation state, a sovereign, to its person, the natural person, the corporate person. We're going to see what the word persons means in this lecture today. We're going to take a brief look at that. So you have this this obligation, what we call a treaty between two countries, and I'll draw my little board illustration. So we have our two countries, two nation states, and they form a contract between them, which we call a tax treaty. And then we have, created by that, and we'll have a little human being, some rights. Now, I'm going to put rights 1. I'm going to put a 1 and a 2 next to some dotted lines. These are going to appear on your screen in a moment. And this is a question for the class I'm going to ask. Now, A and B, that's my countries A and B, just like in our Acme example of 2 weeks ago. Countries A and B, do they really sue each other? I mean, theoretically it's possible. They can go to International Court of Justice, or they can agree on some other kind of tribunal. Their competent authorities can get together and have a discussion. They don't really sue each other. They don't really get into fights that often. So, not under tax treaties. It is possible that they could bring claims against each other in other tribunals, maybe pursuant to a bilateral invent treaty, or being members of the United Nations, subjecting themselves to jurisdiction of the International Court of Justice, by example, over territorial boundaries. But they don't really get into fights. Now, you see the dotted lines of 1 and 2. This is about vertical rights. Vertical rights that are extended by human being, this per down there, by nature of A and B having this treaty, this contract between them. So, under the vertical rights, number 1 is, let's say that my person is a national of country B and is resident in country B, whatever that means. We're going to get to the definition of residencies later. Let's say that my person has income in country A that is in dispute, and that's this little diagonal rights with a number 2 next to it. So here's the question, class. What is this treaty really about? Is it really about number 1, or is the treaty about number 2? Is it about number 1, or is it about number 2? That's a question. You can put your answer in the chat box. Susanna says both. Nobody else has an opinion after having read your chapters 1 through 3? It'd be good to be able to open the discussion of why we thought it was 1, 2, or both. But since we don't have microphones, okay. James is kind of getting there. With number 1, my person, who is a resident or national of B, does he need a tax treaty to protect him against B? He's already subject to the laws of B. He's already within the domestic confines of the jurisdiction to tax, the fiscal sovereignty of B. The relationship between my person and B is established not pursuant to a tax treaty. That's pursuant to domestic tax law. And number two, it's pursuant to just plain old-fashioned domestic sovereignty. So the forgetting tax, my little person there is subject to the criminal laws, to the civil laws, to the commercial laws, to the blah 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 laws of B. And under our theories of political governance and so forth, I don't need a tax treaty to say that my person has rights with B. Now, my question was, which is this treaty really about? Because where my person doesn't have rights, necessarily, is with A. And the treaty is going to extend some privileges or rights to my little person from country A. One of the privileges or rights that we mentioned 2 weeks ago was non-discrimination. That my little person of B would be treated like a little person from A. That country A was not allowed to discriminate in a negative fashion against my B person. We saw by examples that A may favorably treat my person from B, but A may not negatively treat my person from B as in relation to how A treats little people from A. That's an example of an extended right as a result of a contractual treaty relationship between A and B. Now, that brings me back to the word shall. So the rights of this treaty between A and B, between the contracting states, shall apply to persons who are resident of at least one of the states. Shall means my dotted line between A and my little person there on the screen. Country A may not pick and choose when the treaty applies and when it does not. The treaty in relation to A's obligations. I'm about to make an important point here. The treaty shall, in relation to A's obligations, always apply. Here's the important point. Does it require what you're reading, shall? Does it mention that the persons, and in this case it's my natural person, my little guy sitting there underneath B. Could be a company, we'll get to persons momentarily. Does it require that the obligation where we know now, or at least I've told you, that A must apply whatever it says later in the treaty, at least as it regards B, and in this kind of derivative diagonal rights to my little person, must it work in the opposite? The point. Must my person apply the treaty in its relationship with A? Now, what is its relationship with A? Well, we'll get to that and we talked about it theoretically with our Acme situation. Our Acme company created a relationship of investment and business income with the other country when it entered the other country's commercial sovereignty, commercial jurisdiction. And in that case, it set up a branch office, and then it bought into a subsidiary. It became a subsidiary, bought to a company of the other country, a 10% stakeholdership with a bond attached, if you recall. And so it entered the commercial fiscal sovereignty, the commercial and then the fiscal sovereignty of the other country. So my little person has a relationship with A, at least a fiscal relationship with A. As soon as my little person has some kind of income that A can claim jurisdiction over. If we hearken back to our theoretical discussion last week, if my little person doesn't have income that A can claim jurisdiction over, so that was our looking at domestic and foreign source, well then we don't look at the treaty. The treaty is meaningless for this purpose. Looking at our chapters 1 and 2, considering those, holding the information from chapters 1 and 2 of our course book, consider if our person doesn't have income or income from investments, capital, that A claims jurisdiction on, I'm talking fiscal jurisdiction now, if A doesn't claim jurisdiction on it, then we never get to the point of needing the tax treaty. I assume everyone gets this point. If you don't, just say further explain in the chat box. I'm now going to further explain anyway, but from a different perspective. A perspective that we employ in our or at least some people employ in writing their theses. We have A and B, these two countries, and they both, as we saw in the last weeks, have fiscal sovereignty. So we have fiscal sovereignty over, potentially over income, transactions, and we said last week it was either by subject or object were the two operative academic words we use. Subjects are people, and objects are what we were calling types of income or classifications of income or categories of income. And we went through the categories of income: dividends, interest, business profits, capital, and we looked at all these different types of income. So I'm looking at Petrus's comment. Country B does not have to apply the treaty word for word due to the fact that B might have a different interpretation of the word tax. We're going to look at that question, Petrus, of B's application of this to taxes in when we look at Article 2, below Article 1, physically below Article 1 on your screen. So if A and B, which exercising fiscal jurisdiction, and then B is exercising it over its citizen, its little person, and that's all that happens. That's my entire scenario. Then no treaty applies. If my person has an object of income that potentially may be sourced in A, but A does not levy taxation on it domestically, it doesn't exercise its fiscal sovereignty over that category of income. By example, Hong Kong does not tax capital gains. Just doesn't do it. And if my little person has what Hong Kong defines as capital gains that result from sources in Hong Kong, Hong Kong shrugs its shoulders. It doesn't exercise its fiscal jurisdiction. So if B had a tax treaty with A, I think like Belgium has a tax treaty with Hong Kong, I remember now. Holland negotiated one. I think it's in force. Well, I don't have to get to a tax treaty question because my number 2 relationship, looking down at my red figure, doesn't come into play because whereas the country shall, the person may. The person is not required. It doesn't state in the treaty that my little person, with his little derivative diagonal rights here between A and the person, it doesn't say the person shall. The conclusion of that point is that sometimes, as you've read in your chapters, sometimes it is better not to employ a treaty. It does happen that the person will be better off not employing the treaty than employing it. And the general principle that's been derived from this by all treatise authors and through jurisprudence is that a treaty may not make you worse off. The principle is the application by country A in relation to my little person here, the application of the tax treaty may not make the person worse off as regards country A. If you wanted examples of that, we recently were doing Indian jurisprudence, looking at e-commerce issues, and reviewing those treaties. And of course, they're case examples, jurisprudence examples from around the world given in your books. So the principle: treaty may not make you worse off. And another way of, or a way of implementing that principle, the reason that principle exists, is that the person may apply the treaty or may not seek to apply the treaty. That is, the person may seek to have the obligations between A and B countries be enforced, crystallize, or it may seek not to enforce those obligations, crystallize it between the two countries as it applies to the income at hand for my person. We will look later at double taxation when A and B claim overlapping jurisdiction on income. Double taxation potentially that the treaty will solve. Right now I'm looking at the potential situation when the person may not want to use the treaty, but the states shall always apply the treaty and thus allow the privileges and obligations of the treaty to apply to the person. Okay, I'm not going to hype on that anymore. I'll go ahead and clear my little drawings and go back to, that's the word shall. We could further explore the word shall. There's books written on the word shall and treaties and rights and obligations, plenty of that. I'll leave that up to y'all in the reading through your chapters. Okay. Now let's look at the word persons. Now, where am I going to find what a person is? Last week I said we had to go to Article 3, General Definitions. And so we go down. For purposes of this convention, and in this next clause is a little bit tricky because it says unless the context otherwise requires. So this clause, unless the context, modifies, potentially mitigates the shall statement of this convention. For purposes of this convention, for purposes of this tax treaty, I'm going to restate this by adding a word. This convention shall use the following definitions. Modified by mitigated, that shall has been suppressed by unless the context requires otherwise. This is not a may statement, M-A-Y, may statement. This is not the parties may choose a different meaning, or this is not the parties may apply the meanings that are going to fall under our general definitions, the word person being the operative one we're looking at the moment. This is they shall, i.e. will, must, use the following definitions. And then it has this modifier, but who may apply the modifier? Well, either country, A or B, and my person, in my previous example, may seek to state that the shall statement has been modified, that the context does require otherwise. However, going back to our theoretical discussion of the last 2 weeks, why do we have a tax treaty? We have a tax treaty because of risk of investment between two countries. And some of the crystallization or the realization of that risk is double taxation. The risk of double taxation requires us to have treaties. It doesn't always occur. But the risk of it occurring requires us to have tax treaties that we have investments flowing between countries. The context cannot be decided, definitively decided. It can be proposed, it can be put forward, it can be argued. It cannot be definitively decided by and under the laws of, in my previous example just now, of country A. The reason we have a tax treaty is to alleviate risk of my person's investment being double taxed or being discriminatorily treated in country A. If country A were to solely decide when the treaty applied and when it did not, or when the definitions applied or when they did not, well, then I don't need a tax treaty at all, because I'm just back to the domestic law risk associated with investing in a foreign country. Does everyone get that? If country A, at least in theory, if country A gets to decide when something applies, when the context otherwise requires. If country A gets to do that, in relation to my previous example with my little person of B investing in country A, thinking back on the last 2 weeks of lectures, well, I don't need a treaty. The treaty then is just a statement of potential principles that may be upheld between two countries. They do not create obligations. It's perhaps a best practice, but it is not a somewhat binding contractual relationship creating rights. And if you've sat in other tax treaty classes from other people, I don't think you've heard it. I'm sure that you have not heard it explained this way, because I'm referring a lot to domestic ways of perhaps examining rights and obligations without using the more academic terminology of public international law. I said last week I would stop using the academic terminology so we could create a better connection between what we do know and how what we do know applies to the tax treaty. So for there to be a valid reason, a purpose of having a tax treaty, then my little person needs protection from the foreign country, not from its own country. It doesn't get protection from its own country. My little person lives and exists under the domestic rules of its own country, regardless of what the treaty says. But as the foreign country goes, if it gets to decide the context on any treaty article, if the foreign country gets to decide definitively, subject to its own whim, then you don't need a treaty. It's a best practice statement at best. And world trade will slow down. People will no longer invest so freely between countries, because as we saw in the first weeks ago, the risk will seldom be outweighed by the hyper potential profits made in relation to investing in your domestic economy, absent there being other factors such as diversification requirements and so forth. Okay, so the term person, looking at my sub-paragraph A now, what does the treaty apply? Why is resident important? Because we're discussing who residency applies to. We're discussing who the tax treaty applies to. It applies to residents, but to get to residents means any person. So I'm looking at Article 4 again just to make sure that we're staying on track with why we're looking at who a person is. Resident means any person, so now we got to the persons covered. And the persons covered by the treaty are residents, so that brings us back to the residency article. And but looking at any person covered, I looked for the definition of person. I didn't find it in my Article 4. I didn't find it in my Article 1. Brought me down to my general definitions of Article 3. And then now we have three potential definitions of the word person to examine. We have person has been put into 3 categories by subparagraph A. So category 1 is an individual. I'm going to make category 1 be confusing in a moment, just to show you that what seems obvious is not obvious. I'm not going to get crazy on it either. In offshore financial centers, we really tear apart the word individual. Number 2, a company. And number 3, any other body of persons. And just notice that the word person, any other body of persons, which is almost sounding a little bit tautologous. i.e. the definition and the word being defined are in the same sentence. Okay. First classification of person provided by this paragraph A. Now, oops, I won't look at it, but we could look at the word includes. What does the word include mean? But we'll get to that when we look at other bodies of persons. And the point of includes is includes an exclusive word, or is it an open-ended word? Exclusive or non-exclusive? Just like with where we said with the word shall is exclusive. It creates a right, creates an obligation. If it was a non-exclusive word, it possibly creates a right or obligation. Or you could say, in another circumstance of analysis, that it creates a right or obligation to maybe create a right or obligation. The outcome is still the same. It's non-exclusive, meaning it may establish something, however you get to that outcome. So, an individual. Let me open up the word individual. Does individual, if I ask everyone in the class what is an individual, you'll say a natural person, a human being. Okay. Let's look at the U.S. laws for a moment. Is a child an individual? Of course, you say. Of course a child is an individual. Is a child an individual for tax law? Is a child an individual for the right to vote law? Is a child an individual for the drinking age law? Is a child an individual for delict? Is a child an individual for the whatever you call the draft, conscription, or the obligation to register for potential conscription? I forget what we call the draft here, but whatever. You know, we're all registered for it at the age of 18. And so, yeah, selective service, that's it. So, a simple word isn't necessarily so simple. That's all I'm pointing out. Does a tax treaty apply to a minor, somebody who's under 18? Now, not all countries consider a minor to be 18-year-old. Some countries, 16-year-old and below is a minor, or 15 and below is a minor, 16 is majority. And it's what is an individual here, an individual in the tax law, or is an individual under some other broader definition than just fiscal law, than under the fiscal regime? Now, let me even further broaden this little word of individual, which would seem very obvious on its case, on its merits. It's not on its merits, on its just primitive to the actual word. It has to just be any natural person. Well, I start off saying, well, I just gave you a whole bunch of different types of legal regimes. Delictual, can a minor, whatever a minor means under domestic law, enter into a contract? Can a minor be selective service? Can you go fight in the war? Drinking, voting, criminal law. Can a minor be held criminally responsible? Labor law. Okay, I was bringing up that point. Let me broaden it. Let's say that one country, the tax law, the fiscal regime, has minors as independent taxpayers. Let's say that in the other regime, my country B, minors are not independent taxpayers. Their income is amalgamated to their legal guardian, their parent, their natural parent, their adopted parent, their orphanage house, their foster parents, what have you. Now, I'm being theoretical because not so often do minors have income to be taxed. But let's just get weird here. Let's just say that the 14-year-old prince of a oil baron comes to the United States, and he has, investment income or oil is, it's in his name, of $100 million a year. $100 million a year. Now, if the U.S., in my example, recognized the minor, the child in our law, as a taxpayer, and that taxpayer had source income in the United States, or that taxpayer was resident of the United States, subject to tax, absent, suppressed, mitigated the rights of collection, which I discussed last week. One way of looking at how tax treaties work. The rights of collection are suppressed if a tax treaty is in place. And one of the first places to look is my individual even individual? Does the tax treaty apply, or now let's say that the oil baron's state, which has this treaty with the U.S., let's say that it does not recognize the child as a taxpayer, that in its system the child's income is amalgamated to the parent. Is, well, not even amalgamated, not combined, because that would recognize the child as a person to be combined, that it's the child's income was the parent's income. And so, from its perspective, the other country should not be taxing this income, because the income belongs to the majority part of the parent in the oil baron state. The U.S. may not take that same attitude. Now we have a conflict. U.S. wants to tax something that the other country wouldn't normally tax. Or it may tax it, but it may tax it, the objects of the income it may tax, but it'll tax it in the tax subject, the parent, sitting in its country. So the U.S. wants to tax perhaps the child, whereas the other country says we tax the parent. And the two countries, in my little theory discussion, from a subject point of view, the tax subject, child, parent, there's no double tax here. No one individual is being taxed twice. Now the objects, the income, the object, is being taxed twice, but not an individual. The reason I'm walking through this is to show you that this simple word may not be so simple after all. And there may be some very real cases of double taxation that apply, especially for high net wealth families, regarding the allocation of assets of the family group for purposes of legacy or transfer of wealth from one generation to another generation. In the United States, for those of you in tax, I mean, you obviously know the generation skipping transfer where the grandfather gives it to the grandkid. not because he hates his son or daughter, his son or daughter, but because to avoid an estate tax or gift tax transfer between the immediate following generation. Why pay it twice if I could try and only pay it once by skipping a generation? So you certainly can have situations where children have been or child stars, Hollywood stars, children musicians. Britney Spears, when she was 14, 15 years old, making $100 million a year on her record deals, going to other countries that may want to tax her and may not. Okay. So I'll stop harping on the word individual, but I've just shown you that it's not always what it appears. And thus, we need to really closely look at how countries classify types of income and define types of income, define terms in the tax treaty based on what the tax treaty says and the elements of treaty law that apply, so that we can make persuasive arguments that hopefully win the day, whether it's a discussion with a revenue tribunal or hopefully not, inevitably a court. Now, then you get the word company. Number 2, my second classification of individual. With the word company, well, I won't go into it thoroughly today, but it's easy enough to say what is a company in my country is not necessarily a company in your country, and vice versa. A U.S. corporation, such as an LLC, a limited liability company, may not be necessarily recognized in a foreign jurisdiction, and vice versa. Certainly, with the U.S. check-the-box rules in our previous Kinter analysis for what is a company and what's not a company, the 6 characteristics of corporatehood, which, by example, are the shareholders or members extended limited liability as in relation to the debts of the potential entity. And you go through this whole analysis. And sometimes there are many examples where, like, what one country in Europe would consider a company, the United States considered a partnership, or vice versa. What the United States considered a company in the overseas jurisdiction was considered partnership, and you have lots of interplay between that and that. Now, I said U.S., but that happens often between European countries or lots of international jurisdictions. When can, unless other context requires, apply, can that LLC be viewed as a partnership in the other country? Sure, that's the point, is that just like using our analysis for the individual, sometimes what does a company mean? And in Germany, by example, there's no word company. That's an English word. So now I have to look at the German words. In fact, do we use the word company in the United States? Well, traditionally we use the word corporation, but limited liability companies, in some states they're called that. So we have the word company, but generally speaking we call it corporations law. Is there a difference between the word corporation and company? Well, let me proffer this. If there were not a difference then why do we have two words? Okay, it could be just a simple evolution of language, that some word that was popular 50 years ago or 100 years ago is no longer popular, and another word has come to fit its place. That happens in linguistics all the time. But you could make an equal argument that if you have two words to describe the same thing, that the two words have a slightly different meaning. Because otherwise, one of the words would, like in the Darwinian sense of survival of the fittest, one of the words would die off to whichever word was stronger used in the language. And we don't have Darwinian linguistic evolution, I don't think. But anyway, but absolutely, what is a company in one state is not necessarily a company in another state. That meaning, and we have to contextualize this to, the term person includes an individual or a company. Well, does that mean that one of my two countries must recognize what one of the countries calls a company? One country of two countries says that this company is a company. This body of persons, this corporate, this something, this entity has companyhood. It calls it a company. The other one doesn't. Does that get to be included in the term person? Does the term person require both countries to recognize, or one country to recognize? It's something you should examine. That's an issue. Sorry, there's another question. In South Africa, there's a big difference between company and corporation about the size of the firm, 100%. Susanna says, where do trusts fit in? Yes, Susanna, very wise question. Where do trusts fit in? And we briefly mentioned trusts, I believe, last week. Now, and then we'll move on to number 3, any other body of persons. Now, any other body of persons, does that refer to the word company? Or does that refer to company or individual, or companies and individuals? Limited partnership. Limited partnership's general partner is a company. It's limited partners or individuals. Is it a body of persons? Okay. Just so you caught what I was saying. Again, we're just looking at how you analyze things. That what seems like an easy meaning may not be an easy meaning. Notice, I'm just being theoretical here. I don't believe it has this meaning. I'm just saying it potentially does. And I'll show you why it potentially does. And I'm looking at this only in the context of the OECD model. We have to go look at our commentary, and then we're going to have to apply the actual analysis of how one interprets tax treaties that we've read in chapters 1 and 2. So a body of persons includes an individual, comma, a company, no comma, and any other body of persons. Now, this is getting very linguistic. This is getting very like English language, and this treaty isn't meant to be an English language treaty. Now, many countries who don't have the English language as being one of the texts of the You don't have the English language as being one of the texts of the business language, whatever. Let's take I don't know, Swedish and Estonian, or Swedish and German, or Swedish and Spanish. Sometimes when neither country wants to say that the other language is the official language of the treaty, and so they'll say, well, both our treaties' languages are official. But sometimes we get into old big disputes on that, and so what they sometimes say is, as an alternative dispute resolution kind of mechanism, okay, listen, neither of our languages is the primary language for purposes of entreating this treaty. And obviously, if your courts are interpreting the treaty, they're going to apply your language because that's what your judges speak. And my courts are doing it, they're going to apply my language. So saying that both treaties' languages are equal doesn't really help. So we're just going to choose English because everyone in the world uses English. Sometimes countries do that. They choose a third language, almost always English, because it's the world's business language. And they do it for the reasons I just said, because it's they don't want the okay. Now the so here I'm getting a little pedantic on terms of a company and any other body, but if it had a comma, it would be very, very clear that and any other body of persons applied the clause, any other body of persons. The clause applied to both individuals, comma, companies, comma, and individuals and companies. But one could argue that this applies to a company, and in the context of the word company, and any other body of persons, any other body of company-like persons. And that potentially, by example, that a limited partnership that was a company and individuals was excluded from this. I'm not saying it is. I'm showing you one could go there. The word trust. Susanna says, where's the word trust fit in? So what does any other body of persons mean? And that's why I just said my previous statement. Does any other body of persons contextualize, reflect upon company? Because trusts and companies, they're not like. They're dissimilar. And you study that in the trust company course. But for sake of argument right now, just saying they're dissimilar. The word company certainly does not include the word trust. The definition of the word company is not a trust. Any other body of persons, if body of persons is a like thing to company, well then trust is gone. Now, most civil law countries don't have the concept of trust. Most. Some do. Malta is a civil law country with common law mixture, and it has adopted a trust law. Mauritius is a civil law country with common law mixture that has adopted a trust law. We have Japan has at least some facets of a trust law, because I was reading And the offshore investment, just the other week, the new issue about trust law in Japan. So there's a body of persons. Now this brings us to how one actually interprets a tax treaty. If under the chapter reading, go back to the chapter reading thoughts, and my little person has a conflict in the other state. Little person is a trustee of a trust. And my little person wants to say that the trustee is that the income, the object being taxed, belongs to the trustee, but the other country is saying that the object of the income is connected to the beneficiary of the trust. And let's just say in my example the beneficiary is resident in the other country. But the trustee wants to state to the other country, actually, the beneficiary, the income is not attracted to the beneficiary. See, this is a trust, and the income is attracted to me, the trustee. That's the way it works in our country, says the trustee to the other country that the beneficiary is resident in. If the other country doesn't recognize the trust under its commercial, under its body corporate law, can it recognize trust in its tax law? Well, we did say in the last 2 weeks there's a difference between fiscal law and commercial law. We did say that, by example, one may be resident for fiscal purposes, but not be resident for commercial purposes. It is possible. And vice versa is more common. You're resident for commercial purposes, but not for fiscal purposes. The management and control test is what we discussed. So it is theoretically possible that one country doesn't recognize my trustee, this trust, being a person for purposes of this general definition, paragraph A, or subparagraph A, and if we don't have it recognized as a person under this convention, under this general definition, well, then we never get. Article 1 says this only applies to persons. And so, sorry, trustee, you're out of luck. Now, in quick answer to Susanna, though, I'll tell you this. If we go look at the U.S. model treaty, we're going to find that trusts are generally going to be in there when they are meant to be in there. As the negotiation stance, a country that recognizes trusts, the United Kingdom, the United States, all other Commonwealth countries, may, from a negotiation perspective, come to the table and say, hey, we need to include some extra words into the treaty, words that to you don't mean anything, because your courts, under their domestic law, if we have a situation where my person needs to apply the treaty, my person in this situation means a trust. and your country's domestic law doesn't recognize it. So in our discussions, we're asking you to accept a word, to accept the language, to accept the concept that you do not accept as existing, that you don't recognize as the term person, you don't recognize in your legal system. I'm asking you to accept something that you don't accept exists. I'm asking you to grant fiscal jurisdictional existence. I'm asking you to grant fiscal existence under your domestic law as this treaty applies to my people. I don't care what you do with your people. As it applies to my people who have objects of income that you may seek to lay fiscal jurisdiction on, I'm asking you to accept something as existing that you do not accept as existing. That's, when it comes down to it, that's what, when a country like the United States goes to a country like France and says, we want you to recognize the existence of real estate investment trusts. Now, France might turn around and say, well, okay, you know what, we see this as a big partnership. Or we see this as some other concept in French law. And so they agree that France recognizes it in one thing and the U.S. is another thing, but at least it get recognized. Otherwise, U.S. is asking a lot on the foreign government to recognize something, to make something exist that does not exist. Petrus says in South Africa the word body corporate is used for the owners of condos under a certain name example, the body corporate of Acacia, which is just a name for the gated community. This makes the term very confusing depending on the country. Yes, correct. So if we go pull, and we are going to do this in a moment, I'm just going to show you the, well, I have it for Article 4, but I can clear. Okay, let me do something here. Commentary to the article. I have the commentary for Article 4 opened up right now. Let me open up the commentary for Article 3, General Definitions, and I'm going to do that by taking my mouse cursor, putting it over the text of commentary at the upper left-hand corner. I'm going to click open a new window, just showing you how to do it. I'm looking at, I'm just waiting, yeah, it's on your screen, okay. The term person under paragraph 1, the commentary states, and I've highlighted it for you, la 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 la, and then we get to foundation. It clearly covers partnerships and things because it says before you get to foundation, although not incorporated, is treated as a body corporate for tax purposes. In England, in Commonwealth, there are such things as companies without members. In fact, in the United States, there are too. In some states, there are body corporates that do not have members, i.e., they don't have shareholders. It is possible. Also with guarantee companies in the Commonwealth, companies limited by guarantee, they do not have shareholders. They do have members, but they have members who have different types of rights and obligations than those of shareholders, and that's the guarantee as opposed to equity of a share. the guarantee membership is viewed by some treatise writers, by some commentarists, as contractual relation. And one could say, well, all shares are contractual relation. I argue differently. I say that shares, equity, is not merely a contractual relationship. It is a somewhat higher on the threshold, like property. That that equity grants. I won't go into it now, but I have three levels of contractual relationship, the simple one being contract, and then the highest form being the property rights in terms of our commercial law, and then something between those two. Now, thus, a foundation Stiftung may fall within the meaning of the term person. I've highlighted that. Now, that means something in civil law. Stiftung, foundation, but that's not what a trust necessarily is. Trusts have been compared to those, or those have been compared to trusts, but they're not. When we look at the characteristics, they're not the same. And as we scroll down through our commentary here, and we see that the term company, the term enterprise, and so forth. Anyway, the point is guess what we're not going to see here? You guessed it. We're not going to see the term trust being defined in the for person. Well, if let's go open up my Internet Explorer and pop over to Tax Analyst and see what the U.S. model has in response to Susanna's question. So I've popped open my proxy server, International Tax databases, click on my Tax Analyst, Worldwide Tax Treaties, clicking on my model conventions, and the United States at the bottom. I'm going to click on the Model Tax Convention on Income 2006. I'm going to open up the Article 3 General Definitions. Let me minimize this so we can contrast it against the I'm going to close what's behind the screen. Okay. So on here, I'll put it side by side. So here we have Article 3, the OECD model. And next to it, I have opened up the U.S. model. And Susanna, in answer to your question, what's the difference? So when the U.S. comes to the table for its negotiation stance, there's two extra words here that are very important to the U.S. tax system. estate, and trust. Oscar says add foundations to the entity menu and you get confusion. Well, foundations is certainly added because foundations is specifically mentioned in the commentary as being like a body corporate persons. In my example of the guarantee membership, my second classification of rights would be my proprietary rights, that you have some kind of proprietary rights in this body corporate as a guarantee member. Do you have proprietary rights as a foundation? You're not a shareholder in a foundation. You're not a member either. Whatever you are, you're a relationship. Is your relationship proprietary in the foundation? Beneficiary. Beneficiary. Yeah, foundations and beneficiaries, correct. Like a trust. So is it a proprietary relationship? In a trust, the beneficiary has a property interest of some sort in the corpus, the assets of the trust, in that it has an interest, a beneficial interest. And is it merely contractual? Because some people, when they teach property law and when they teach trust law, they state that, property law is just a bundle of rights. A bundle of contractual rights is really what they're getting at. And I guess that inevitably that's one way of looking at it, and it certainly on its face seems to be obviously true. It's obviously a bundle of contractual rights. However, for those of you who are perhaps Lockean or natural right people, libertarians, you might consider that there is some kind of natural right, proprietary rights toward ownership of property, something other than just merely a Machiavellian sovereign granting authority that rights may come into existence, depending on what the sovereign says today or not. So the Lockeans might say that regardless of what the sovereign says, the sovereign cannot legitimately take away your proprietary rights in property, that expropriation is illegitimate based on other theories than simply the sovereign. Because if it's based on the sovereign can do whatever the sovereign wants to do, which is kind of Hobbesian, but Hobbes was not against natural law. Okay, so here, in answer to Susanna's question, I have found that an estate and trust is included in my definition of persons under the U.S. Model Treaty. What other kind of persons need to be included? Well, without going into such detailed analysis that I've been doing, we'll find out that under the language of the model, the OECD model, political subdivisions are included. We'll see that charities may be included, because we've only gotten, for purposes of Article 4, which is what we're really looking at, the term resident. We only got as far as the term person. We haven't yet addressed the part of Article 4, the next part that says is liable to tax. And I'm going to conclude because it's coming up on 10 o'clock, 2 hours. But we're going to take this up on Thursday because this goes into principles of international tax. Also, it's liable to tax, and we have to look at the domestic tax law. What does that mean? Versus this treaty interpretation of persons that we've been looking at, individuals versus companies. What kind of persons are also out there in the world? We have mutual funds. Are mutual funds covered under the term persons for Article 3 that then decides whether we get to Article 4. And for Article 1, persons covered, i.e., no person, no coverage, no treaty, no discussion. You don't get to play the game. Now, mutual funds, they have to be perhaps specifically recognized in the negotiations process. The term persons under General Definition 1, subparagraph A, must spell out, and so if we go pop open a real treaty, let's just go do that. I've popped open the model here for the purpose. And we can go look at the U.S. technical explanation, which is kind of like a commentary, which is only relevant for U.S. treaty discussions, and is certainly not relevant for interpretation of a U.S. tax treaty in terms of convincing a foreign court, because the foreign court's going to turn around and say correctly, what do we care what the U.S. thinks when it goes to the table to negotiate a treaty? That's between the U.S. and its people. But it's persuasive in understanding what the U.S. authorities have publicly stated that they're thinking. Though what one states publicly and what one actually means can be very different. And hopefully so, because in geopolitics, leaders state very harsh words toward other countries. In actuality, those harsh words may be lifelines, because instead of harsh words, they could be going to war, by example. So the words aren't as harsh as something said before. So if I'm just going to pull an enforced treaty out, and we'll pull open a U.S. treaty, since we were looking at the United States model there, and so for I don't know, let's look at the U.S. Netherlands. That's always interesting to look at. So 1992 Income Tax Convention as amended. We're just going to scroll down to R3. Okay, first we have to define what a state means, because the Netherlands is overseas territories. The U.S. is overseas territories. I don't know, well, overseas, but certainly over the ocean. It has, overseas, Caribbean Sea, Puerto Rico and U.S. Virgin Islands, Guam, and other possessions, Palau, Northern Mariana Islands. Okay, then we get down to our person. So the U.S. in its treaty with the Netherlands says a person includes an individual and a state or a trust. Same language we saw in the Model Convention. And then we'll see in notes exchanged between countries that the U.S. may include like REITs, real estate investment trusts, mutual funds, and so forth specifically, or not the U.S. includes. The two countries agree to have those included. Okay. I'm going to clear all the writing. So what we did today was we started to examine from different perspectives who is covered by the treaty. And we started with 4 to show how it relates back to 1 and 3. And then we started to dissect the simple word individual to show you that What appears obvious is not so obvious, and we use the example of child for that. Children. The analysis will continue on Thursday in relation to the word liable to tax, and it will then extend to the second part of the discussion on Thursday, which will be domicile, residence, place of management. The second sentence of the first paragraph, I encourage everyone to be studying this week, in particular as it regards the United Nations Treaty, and there is some course literature provided to you, tutorial on the second sentence. Because in the United Nations Treaty, let me pop open on your screen your Klaus Vogel book, by example, which I have accessed through my proxy server, CCH Tax Research Network, the International Tax tab. And I look at my United Nations model here. I could look under tax analysts. And what I see in my UN model is that there is no second sentence. The second sentence being, does not include any persons who is liable to tax in the state in respect only of income from source. I've highlighted at the top of your screen, only from source in the state or capital situated therein. That sentence is not in the UN Model Convention. Perhaps somebody will tell me why it's not in there next class. But for your listening enjoyment, one of the 20 tax treaty lectures I gave last year, one of them that recorded happened to have been on that second sentence. And so that's available for your listening pleasure next week. And Alan de Coker, who is from a source-based country, it's changed now. South Africa is now residency-based, but used to be source-based. So he grew up in a source-based country as a tax practitioner and professor, understands the UN model, because South Africa, while it's an observer to the OECD, and certainly respects international trade and rights and so forth, and wants to encourage direct income flows into South Africa, as discussed in our first two lectures, the UN model, at least in this context, is very apropos for South Africa's negotiation stance, or at least was. And okay, and then de Coker will be taking over. I'll still be sitting in on the lectures because I have to guide him into using Mega Meeting like I do every year to all the teachers. Okay, I'm going to close that out. I'm just showing you that this is from the Vogel and Double Tax Conventions. I could hit related topics and so forth, but I'm not going to do that today. I'm going to close out everything on the screen. I'm going to stop showing my screen. Stop showing my screen, and say, does anyone have questions based on our examination of the words today? Video layout to auto. Okay. I don't see very, okay, I see students showed up after we started. Good. Okay, I don't see any questions. So I'm going to go ahead and we have meetings here, and I see lots of people have been calling me this morning. So time for me to go about my daily duties. And I'm going to stop recording.